It's Entertainment Law Update number 186 for December of 2025. And here we go. Hi, everybody, and welcome to Entertainment Law Update from Los Angeles, California. I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera Bennett.
And we are so glad that you have chosen to join us for this episode. This is our podcast by entertainment lawyers about entertainment law for entertainment lawyers and others who are interested, where each month we round up the notable cases and the news and information and try to keep you informed and hopefully a little entertained. And this is our year-end roundup. And we're just giving our completely unscientific view of the top stories that we think were important this year. And as always, we do welcome your feedback and suggestions and input. So please visit entertainmentlawupdate.com and use that little voice widget. It's a little red tab on the side of the screen. You can leave us a recorded message and tell us what you think. Hopefully, be kind. Tell us what you think. Or you can send us an email to entertainmentlawupdate@gmail.com. And before we get too far into things, I want to say a shout out to Kate Brolin, who is an entertainment and media lawyer from the Sacramento area here in California, who came down to LA for the American film market last month and was nice enough to reach out to me. We had a lovely breakfast together at the conference hotel, and it was just nice to get to know a listener and fan and make a new friend. So hello, Kate. Thank you for that. And thanks for listening.
Yeah, Kate, I look forward to meeting you as well.
And
we'll make that happen.
Tamera, you said there's some upcoming CLE presentations you want to share with us.
Yeah, so super excited. I actually just did a CLE presentation last week with my associate attorney, Jordan Hendricks, and we're taking this show on the National Road and going to do a live presentation through My Law CLE at 1 p.m. Eastern coming up January 22nd. Trademarks in the Wild, Real-World Lessons from Rogers, Jack Daniels, and Pop Culture Litigation. So we're going to give some practical application of balancing trademark rights, First Amendment rights, artistic expression, and how all of that fits in post Jack Daniels. And we'll give a little preview of some of those topics later on today in our podcast episode.
Yes, indeed. So stick around for the year-end roundup part of the episode. But before we get to that, we are going to get into some of the recent case law and news things that have come up in the last few weeks since our last episode. And we'll start off with a discussion of Willis versus Walt Disney Company. Victor Willis was the founding member of the band The Village People, and after years of trademark battles over the name of the band, Victor Willis was successful, and he reformed the band and signed a deal with Disney for a pair of live shows at Walt Disney World in May of 20. Oh, I forgot to mention, since Walt Disney World came up, I'm going to be in Orlando for the Podfest Expo in mid-January, January 15th through 18th, and I'm speaking about using AI in podcasting, the ups and downs of that, the perils and pitfalls, I guess you could say. So anyway, if you're going to be around Orlando, reach out to me and we'll set up a meetup or something. But anyway, back to a pair of live shows at Walt Disney World in May of 2018 for the Village People. Well, according to Karen Willis, the wife and manager of the Village People, manager of Victor Willis, the co-founder, those concerts were jam-packed, turned out fantastic, but then a short while later, things sort of went sour, and a rival lineup, according to her, a group of former members of the band calling themselves Six of Us, one word, pressured Disney to steer clear of the reformed band. And not long after that, Disney did quietly impose a do not book edict against the real Village People, the Victor Willis group. So her lawsuit in 2023 accused Disney and its entertainment executives of fraud, unfair competition, civil conspiracy, saying that they misled her and the band's booking agents by pretending to consider future shows, all while imposing a secret blacklist on the group. She was looking for $400,000 in compensatory damages and $20 million in punitive damages. But Disney denied all of it, and the company argued there was no blacklist, and they pointed out that a Disney affiliate had even booked the band for a Thanksgiving parade after the alleged ban supposedly took effect. So Disney filed an anti-SLAPP motion, and under the California anti-SLAPP law, if a defendant shows the lawsuit targets protected speech or expressive activity on a matter of public interest, then the case can be dismissed early and there's fee shifting and so on, unless the plaintiff can show a probability of prevailing. So the trial court wasn't convinced. They said Disney's decisions about which bands to book weren't protected speech and denied the anti-SLAPP motion. So Disney took an appeal. And the appellate panel here in California, Justice William Datto, saw things differently. The court said that Disney's choices about who performs on its stages are indeed expressive and therefore protected. In the court's words, music is a form of expression and communication protected by the First Amendment, and then went further, explaining that booking decisions themselves can qualify as protected activity because, quote, there can be no reasonable dispute that Disney's selection of the musical acts that will or will not perform at its live concerts has the requisite degree of closeness with a public issue because it directly dictates the music that'll be played on the Disney stage. So in other words, Disney's curatorial choices are part of its creative expressive output, not just business decisions. So the appellate court also reminded us of how the anti-SLAPP test works. The defendant first has to show that the lawsuit arises from protected activity. And then if that's proven, then the burden shifts to the plaintiff to demonstrate that the claim has minimal merit at least. So Disney cleared the first hurdle. The appeals court reversed the trials court ruling and has sent it back to the next phase to determine whether there's any likelihood of success by Willis's claims. So the court didn't actually look into whether or not there was a blacklist or whether the company misled the band's agent. It took the more prudent course, in its own words, quoting prior precedent, and sent the matter back to the trial court to make a decision on likelihood of success on the merits and so on. So anyway, so the case proceeds.
Do you think the anti-SLAPP has been applied too broadly, too narrowly in California?
I don't hear about it that much. I think it's been, in this case, I think it's about right. Okay. I mean, does Disney really need the protection? I don't know. I think probably not. But, you do what you can to fight these kinds of cases. So, I don't know. I think that it's a useful tool for defendants that are mostly, I think, like Disney, who don't really need that shield. They can afford to litigate. They can manage the fight. They can handle things. And I think oftentimes, because it's such an early motion, it forestalls discovery in the case that might reveal valid basis for liability and things like that. But I don't know, if I was being defamed, I would frame my complaint in such a way, if possible.
Right.
But again, if somebody's just engaging in expressive speech, then, mixed feelings about it.
I was just curious. What you thought now that I don't know how many years it's been.
Yeah.
10 years?
It doesn't seem to come up that often, or at least we don't hear about it being, up on appeal very often. I imagine there's lots of cases dismissed early on under anti-SLAPP regulation that we just never hear about because plaintiffs don't have the wherewithal to go up on appeal with it. So
yeah. All right, so we're going to go from California to Texas.
Your home turf.
My home turf, the Woodlands Pride versus Paxton out of the Fifth Circuit, 2025. So in 2023, Texas lawmakers passed Senate Bill 12, and it's a law criminalizing so-called, quote, sexually oriented performances in public or in the presence of minors. There could be fines, even jail time. Community groups such as the Woodlands Pride Inc., Abilene Pride Alliance, small entertainment companies, some performers actually brought suit against Texas Attorney General Paxton, local officials, arguing the law is vague. It would chill drag shows and pride events that include artistic or comedic gender performances, claiming a violation of their First Amendment rights to free expression and their 14th Amendment right to due process. The state countered that the law simply protected children from obscene conduct and it didn't target drag or any specific viewpoint. After a 2-day bench trial, a federal judge in the Southern District of Texas sided with the performers and declared Senate Bill 12 facially unconstitutional. That's important, the facial unconstitutionality, and finding that it swept too broadly and suppressed protected expressive conduct. And the judge issued a permanent injunction. On appeal, in the Fifth Circuit, they didn't really jump straight into that free speech analysis. Instead, they focused on the question of standing. Who had the right to sue whom? And whether the lower court had used the proper facial challenge framework from a recent Supreme Court decision in 2024. The panel emphasized that to sue a government officials, they needed to show, 1, a concrete injury, 2, that the injury is traceable to that specific official's conduct, and 3, that a court would likely redress that harm. The Senate Bill 12 actually delegates enforcement to different officials for different parts of a violation of the Senate bill. Part of it goes to the Attorney General, some to local prosecutors for criminal cases, and some to city governments, actually. And the Fifth Circuit said that the plaintiffs did not link their injuries to each defendant's enforcement power. So they did link their injury to the Attorney General's office, but not to these other lower governmental entities, the more local governmental entities for enforcement of that. Then they looked at this Moody issue, and the Supreme Court's decision in 2024 changed how courts analyze facial challenges under the First Amendment. Under Moody, a law isn't facially invalid unless its unconstitutional applications substantially outweigh the constitutional ones. Courts must compare the entire field of potential applications before striking a law down, and the Fifth Circuit found the district judge never did go through with that comparative analysis and remanded the case. So what this means is that the Texas drag performance law is still blocked against some local officials, those who didn't appeal, but the rest of the injunction is on hold while the lower court reexamines the case. And again, it's not necessarily supposed to be targeted just to drag performances, but obviously these are the parties, the plaintiffs that have brought this suit. So it's on appeal as the courts reexamine it. But it was interesting that several officials did not bring suit on the appeal. So
apparently they were the ones that never intended to enforce the law.
They never intended to enforce the law. So Austin area, Travis County, and some other areas. So the law will not be enforced, I guess, in those. It has not been enforced in those areas.
It's interesting. I mean, is that the mechanism that you would expect to use to sue the individual public officials rather than just sue the Attorney General on behalf of the state because the law is unconstitutional? I guess you have to claim a valid. You
have to name.
Threat.
I mean, I will say Ken Paxton is always a named defendant.
Right.
In any of these cases for enforcement of any of the legislation.
Okay. All right.
On whatever grounds it may be.
Sure.
He's always the defendant.
Yeah. No, that makes sense to me. I just, wonder.
Yeah, I guess you've just got to have a named
just this fragmented application of things on the standing question. Well, if they have standing against the state because the law itself is unconstitutional, does it matter if you have standing against the local officials? And does that injunction have any meaning if they were never going to enforce it anyway? So yeah. Oh, interesting.
We'll keep our eye on it and see what happens.
That'd be interesting.
I'm not aware. Are you aware of any other state legislation along the lines?
I'm not. I imagine there have been similar.
There probably are. Yeah.
So this may become a a case worth watching from other states that have similar laws. So we'll see.
Yeah.
Well, I remember fondly this movie, Who Framed Roger Rabbit? And it's funny, I haven't seen it in years, and I think it's time for another rewatch, but because it was such a fun, at the time, it was a technological advance.
Oh, yeah.
Those who don't know the movie, it's a live action animation hybrid film, sort of I guess it starts out as a murder mystery, very comedic, of course, with animated characters and so on. And the famous line, Jessica Rabbit says that, I'm not bad, I'm just drawn that way, which is such a cute line. What were you going to say?
Okay, am I dreaming? Is Michael Jordan in this? Or he's in Space something?
Space Jam with Bugs Bunny. Yeah.
Okay, sorry. Excuse me, people. It was a rabbit, at least.
Yeah, a year or two later, I think they did that.
Okay.
Now that the proof of concept. Yes, a rabbit can anchor a series film, I guess. But
okay.
Anyway, this is a little different from our usual year-end where we're looking at the high-profile works that are falling into the public domain and things like that, which we'll be covering in the January episode. But some unique news here where it was basically a termination of transfer under Section 203 of the Copyright Act. Gary K. Wolfe, the author of the original, I guess he's the writer of the original screenplay, but also of a book called Who Censored Roger Rabbit and its sequels, was able to recapture the rights concerning his stories back from the Walt Disney Company that had made the film. He has indicated his interest in using this to attempt to make new films based off of his new book, Jessica Rabbit, Serious Business is the weird spelling of things. I guess what's unusual is it seems to have been sort of an uncontested termination of those transfer rights, termination of the transfer. But apparently it was a settlement essentially, and they agreed that he agreed to some quality control measures to make sure that any other films that come out will not reflect badly on the original Who Framed Roger Rabbit.
And I think the effective termination date was in 23. So it has taken them a little time to work out the details on it. So is it Disney?
Yeah.
Who released it? Sorry. So Disney obviously can continue to display and distribute Who Framed Roger Rabbit. That's not cut off as part of the copyright grant termination notices.
Right. And then we still have that open question of the Vedder versus Resnick situation of whether or not the termination of transfer is worldwide in effect or just in the U.S.
Yes, right.
And we'll be talking about that case again in a few minutes. But let's move on. Let's talk about some of the cases that have come up. Look, AI has been big for us, and this month is
well, I made a note as we were kind of assessing each of us and our contributors assessing what we thought the top cases were, and I was like, I'm struggling to come up with 5 top cases when all 5 of them are probably AI out of the whole year,
and that was common across all of us.
Felt strange. Okay.
I tried very hard not to. I made AI sort of was one category of cases, and then, So as we get to our year-end roundup, we'll get back into that and explain what's going on there. But first off, we had a couple of interesting cases that came down in the month since our last episode. A court in Munich has ruled against the American company OpenAI that ChatGPT infringed on works by Herbert Grönemeyer and others, and the judge ordered a damage award. OpenAI had argued that its large language models were not storing or copying training data, in this case it was song lyrics, but they were able to reflect based off what they had learned from consuming those contents, those materials. But the court found that because any language that the language model memorized the lyrics and could reproduce them in output, then it was liable for infringement. So that's sort of I don't know if it's groundbreaking, but it's definitely something we haven't seen in the American cases yet, looking at the outputs specifically. But OpenAI argued that it was the users that were doing the infringement, not the tool. And I don't know how you feel about that, but I don't buy it. If the machine does what the user wants it to do, and that happens to be duplicating a work, it's still infringing, and it's at least contributory, wouldn't you say?
I would say it
Yeah.
is. I mean, that's what suits have been brought by National Music Publishers Association and others here in the U.S. against ChatGPT for that precise reason. I mean, I haven't done it in a while, but
Yeah.
I will go in and ask it to reproduce song lyrics, and
Well,
it's amazing.
I think most of the companies have instituted some guardrails when if you ask for the song lyrics and you want it to output, it'll sort of say, "I'm sorry, I can't do that."
I'll try it again.
But
It's been a while since I've done that.
But I think there are some workarounds, and apparently OpenAI didn't do that for this particular set of song lyrics or whatever. We wanted to include this German case just sort of to illustrate and remind us that, it's not just here in the US where we have lots and lots of these lawsuits, but there are somewhere between 50 and 60 AI lawsuits going right now, mostly here in the US, but also in England and other countries. And it's interesting to sort of see a German court getting right down to business with looking at the output. And I imagine this will be we'll see more of that as we go. I think the British case involving, I want to say, Getty Images is looking at similar issues and moving along pretty well. So
yeah, and I just want to plug in there to say, and we're only talking about intellectual property pushing type cases, fact pattern cases. There's a whole body of criminal law cases involving AI too. So.
And defamation cases and privacy cases. Yeah, so there's a lot
all kinds of things.
We haven't had occasion to talk a lot about the defamation cases. I think early on we did with, mistaken identity sorts of situations with the AIs, identifying the wrong person and things. But anyway, the other interesting AI news story that we have is Advanced Local Media versus Cohere, Cohere Inc., filed in February of this year by 14 major news and magazine publishers. The Southern District of New York has denied the 12b6 motion to dismiss, ruling that the case was in fact sufficiently pleaded. Basically what the case is about is that substitutive summaries, that is non-verbatim outputs that mirror the expressive structure and journalistic storytelling choices of original work, may plausibly infringe copyright. So there's enough here to let the cases go forward. So here we are again, looking at the output and saying it's close enough to a protected original work that at least there's enough for the case to move forward to a jury. So that's an interesting development, looking at the outputs. So maybe that's the trend we're looking at now. So, or
at least not enough to get it on a motion for summary judgment.
Right. So anyway, so we got those are our only AI news summaries in this, so I guess, relatively quiet month in the AI world. I haven't looked at that. There's a great website, chatgptiseatingtheworld.com, and or maybe it's .org, and it is a great. It's sort of an updated summary of what's going on in the AI, all the AI cases around the globe. So worth checking in on once in a while, and I just didn't do it this week. So anyway, what do you think about this case of the marriage of Strong? This is it's concerning, but let's talk about it. So it's a California appellate
case in the marriage of Strong. So they're no longer husband and wife. The parties are already divorced, and it's an appeal. It's in an appeal ruling from the Second Appellate District. The appeals court ruled that a copyright can be seized as an asset to satisfy judgments, not the royalty stream, but the actual copyright asset. So Brett, who was the husband, was a sculptor and owned a copyright on some collaborations with Michael Jackson. Monique, his ex-wife, asked that the copyright be transferred to a receiver so she could monetize the copyright and pay ex-husband's $2 million in unpaid spousal and child support. And the trial court did so and transferred the copyright as his sole asset. Brett, the creator and owner of the copyright, argued that copyrights cannot be forcibly transferred. The appellate court, looking at cases from the 19th century, from 1881, ruled that no, courts can transfer any intellectual property from a debtor to their creditor. Notably, this has not come up before in California case law. The judge did look at patent law and applied that as an analogous standard. And Brett and his team argue, no, we're not the same as patents because patents have a shortened lifespan.
Sure.
And of course, the court is arguing, well, if it needs to be monetized, this is a way to pay off your debt. And I am a little concerned because I think there's a big difference. The court also said they just didn't argue that well enough. They just didn't get enough, I guess, sportive case law in there to distinguish a patent from a copyright and how the revenue stream works. But when you're looking at a copyright, that's the life of the author plus 70 years after death. We're just assuming this was not a work for hire, which I guess it's not if he's listed as the author.
Yeah.
That could potentially lead to a windfall well beyond the $2 million that's owed and other. It maybe not. Maybe there's not that much value to it, but it sets a
right. So the receiver's job is to take the proceeds from it and pay off the judgment, or in this case, it's a spousal and child support award.
I'm sure it's been reduced to a judgment, probably.
Yeah. And so if there's an excess, I would assume that the receiver would, as a fiduciary of both of the parties in the case, would have to distribute the balance to the other.
Then why didn't they just transfer the royalty stream?
Well, probably because the plaintiff didn't ask them to transfer the royalty stream. And again, it wasn't argued or pled well, probably.
Yeah.
But what is the rationale for saying that a copyright is different from other forms of property? If it was a car or a bars of gold in a bank vault,
right? Or let's do property to property. It was a piece of real estate, which could increase in value.
Yeah, I mean, I think the one argument is that because the copyright law provides for its own rules of succession and inheritance. Maybe that's why you could justify treating it a little differently, because Congress saw fit to do that. Maybe it should be a different class of property or something. But
does that mean he could terminate the grant?
Well, that's it raises some interesting questions.
In 35 years?
Yeah, right.
Yeah, I think it does.
Maybe.
I mean, I don't know. We'll have to wait and see.
And do those sections about termination apply to transfers handled as a function of a court order rather than a grant by the party, the owner? Something to live.
Well, he still has to sign the assignment.
He was ordered to do it. Well, I don't know. I mean,
I think he would have to have been ordered to sign an assignment. I don't think the court can just come in and do it without the physical papering.
Well, and back to the question of a real estate deal. Could a court order a deed be entered in the name of, without without requiring a transfer document? Well, I guess a deed is. I don't think so. Yeah, I don't know.
I don't think so.
And maybe that's.
I think they can order you to sign a transfer document. In fulfillment of their order.
This is the judgment. This is the order fulfilling. Yeah.
And then I think you would do the same thing on a copyright.
Yeah.
I know you would do the same thing on a copyright. You would submit the order and then you would submit the supporting documentation that fulfills the order. You would do that for a deed at the county clerk, and you would do it for a copyright at the Register of Copyrights.
Yeah, I don't think a state court judge would be able to do it, but I wonder if a federal court judge could just order the Register of Copyrights to register the work in the name of this party as a result.
They can't.
Okay.
Mm-mm.
Interesting. Well, okay. So
somebody correct me if I'm wrong, but I think the compendium in the Copyright Office is clear on that based on recent research I've done.
Okay.
That the court can order the party
to transfer.
That they must take the following actions.
Yeah, that makes sense. That's who they have the jurisdiction over. Yeah. Okay. Well.
So I think it's interesting. We'll keep an eye on that.
Yeah. Well, the big news this month has been the Netflix, Paramount, Warner Brothers brouhaha, what promises to be a seismic shift for Hollywood is Netflix has proposed to acquire Warner Brothers Discovery for, what is it, $28 a share, totaling $72 billion. This promises to rewrite the rules here in the entertainment industry, and certainly the film and TV industry. Well, and music too, Warner's, right? It can, assuming that it gets past the regulatory hurdles. There was this whirlwind bidding war. Netflix emerges victorious, beating out rivals Paramount, Skydance, and Comcast to acquire the Warner Brothers Film Studio and HBO Max streaming service. I guess is it called Max? Yeah, it's HBO Max.
Yeah.
They put the HBO back on, right? That's what it was. Anyway, so the price tag, $28 a share, $72 billion. Now, the deal is not including the Discovery linear television assets, CNN, TNT Sports, the Discovery networks, those kinds of things. Those are expected to be spun off into a separate entity likely to be called Discovery Global. And Netflix will absorb all the premium intellectual property and the studio itself. To prove they're serious, Netflix actually agreed to a breakup fee, $5.8 billion, which they will pay if the government blocks the merger.
Okay.
And yes, the government is watching. If the deal closes, it makes a media supergiant, and the combination will take Netflix's 300 million global subscribers along with HBO Max's 128 million, and that would control 56% of the active user market for streaming. But the biggest anxiety isn't about the streaming, it's about the box office. So there's a group of A-list producers and filmmakers that have anonymously sent an open letter to Congress warning that a Netflix-owned Warner Brothers could effectively hold a noose around the theatrical film marketplace. So the fear is, of course, that Netflix will slash the theatrical window, which has historically been, 6-8 weeks sometimes and longer. And Netflix insisting that it will honor the theatrical commitments of Warner Brothers and sources. That's current commitments, but what happens going forward, right?
Mm-hmm.
Sources suggest the streamer had proposed a theatrical window as thin as 2 weeks before moving movies over to streaming. And that contrasts sharply with what the rival bidder Paramount Skydance had pledged, which was to keep Warner Brothers operating as a standalone business with a minimum of 14 films a year and a proper, or I should say, traditional style theatrical windows and so on. Industry veterans skeptical of Netflix's assurances, pointing to past comments by Ted Sarandos, the co-CEO of Netflix, who in 2023, as recently as 2023, said that driving folks to a theater is just not our business. So, what are the legal hurdles? Well, first off, the Trump administration is viewing this with skepticism, heavy skepticism, as it's described. Senator Elizabeth Warren has slammed the proposal as an anti-monopoly nightmare, warning it could force higher prices on consumers, limit choice, and the DOJ is expected to review the merger closely. Process could take over a year. Netflix plans to argue that the definition of the market should be much broader than just streaming services. And they will also claim that YouTube, TikTok, gaming, all of these compete for the total audience attention span, and that therefore Netflix-owned Warner Brothers would not be a monopoly. And then there's the personal side of things back behind the scenes. Paramount's David Ellison, the reports say that he may have lost the deal due to bad blood between him and David Zaslav, the CEO of Warner Brothers, stemming from a failed negotiation over rights to South Park, who are no friends of the Trump administration. The lawyers have already accused the bidding process of being rigged, and Paramount has now begun a hostile bid to unseat Netflix's offer. That bid, launched just last week, offers $30 per share in an all-cash transaction valued at approximately $108.4 billion, aiming to take control of the entire company, not including the cable networks, CNN, and so on and so on. So that's the thing. So Netflix is raring to go, but the deal is far from done. We've got the angry filmmakers, the hostile competitors with ties to the White House. That's the other thing is David Ellison, whose father is Larry Ellison, the founder of and CEO of Oracle. They have very strong ties to President Trump. So, and the regulatory scrutiny, all of this, it's going to be a trench war. Netflix is trying to buy the crown jewels of Hollywood. I would say not trying to buy the crown jewels, it's trying to buy the throne. Maybe the whole castle, right?
Yeah, and so let's say Paramount had succeeded or does succeed. I guess we not have the issues regarding theatrical releases because Paramount is in the business of also theatrical releases or not?
Well,
does that go away?
Well, that also raises other related antitrust concerns, doesn't it? Because if Paramount is in the business of theatrical film and Warner Brothers is, and there are only 5 sort of major studios now, 5?
Mm-hmm.
Universal, Paramount, Sony, Warner Brothers. Am I missing one?
To Spielberg, what's...
yeah.
But is it owned by somebody else?
It's tied to Universal, but it's a standalone studio. But the point being, as a distribution companies, then wouldn't Paramount owned Warner Brothers essentially be a giant monopoly in the distribution end of things and production end? So similar concerns, but because Paramount is in the theatrical film release business, yes, they have a streaming service, but they're still in the film production and television production. Right. I think that they might be situated to do things differently. And they're not as invested in just being a streaming service. Netflix really is a streamer. So, I don't know. I don't know that either deal could go through. $108 billion. It'll be interesting to see what the shareholders have to say.
Right.
I mean, Ellison and Skydance are giant shareholders in Paramount, but Netflix's shareholders are the ones that we have to worry about. And Warner Brothers shareholders. So it will be interesting, and I imagine there will be lots and lots of maneuvering. We'll be talking about this for a while, I suspect.
Yeah, this will be on our radar for next year.
Yes, it will. Yes, it will. Well, that brings us to the segment or the part of the show where we're going to talk about the top stories in 2025. And as we signaled, AI is well represented among them. You want to take this first one?
I will. So, top stories, 4 AI stories of the apocalypse. I don't know. Thomson Reuters versus Ross Intelligence. We discussed this in episode 177 most recently, but we've discussed it many times before then. Thomson Reuters won the first major AI copyright ruling in the U.S. They claimed the AI firm Ross Intelligence reproduced materials from its legal research firm Westlaw, specifically the over 2,000 of Westlaw's head notes. And they used those, Ross did, to train its AI-powered legal research platform. This was the first in what will likely be a lengthy process of fair use evaluations where Thomson Reuters prevailed in a summary judgment motion determining that their head notes were infringed.
So pretty specific set of facts. I mean, the head notes are definitely proprietary stuff. So if it reproduced those things, then it's a sort of a smoking gun, isn't it?
Well, right. And we all, as formal law students, remember how proprietary head notes are, or at least we should. You can't do not cite those
right
in a paper or in a brief.
Right. It was beaten
because they're
us.
Not the law.
Right.
They're not the law.
That's right. That's right. Well, another case that came out this year is Thaler versus Perlmutter. This is that I guess he's a computer science professor who we discussed this case back in episode 179 in April. He was attempting an appeal of an earlier ruling to get him to be allowed to register the works that he created using his AI, the creativity machine, based on his ownership of that machine. And he has lost at the trial level, lost at the Copyright Office, lost at the trial level, lost at appeals level, and submitted a petition for cert in October that has now been denied. So the rule stands that works that are made solely or primarily by AI are not entitled to copyright protection and registration. So big case, lots of ramifications going forward. Supreme Court declining to rule, that tells us something, at least for now. they've got bigger fish to fry, or at least more interesting fish for themselves to anyway. So there we are. And then we have the big one. You want to do this one?
Sure. Bart's versus Anthropic, discussed multiple times this past year, but most recently in episode 182. One of the first major court rulings related to AI training and copyright found that training Anthropic's Claude model on legally purchased books falls under fair use, describing the process as quintessentially transformative, comparable to a writer learning from other authors to develop a unique voice, but drew the line at pirated copy and contents. So with over 7 million books that were not secured via purchases and not secured appropriately or pirated, they were excluded from that fair use analysis. And trial was set for this month, but settled for $1.5 billion, though the settlement, as we discussed in the earlier episode, has been criticized based on the lack of transparency. And we kind of outlined many of those factors in episode 182.
And sort of interesting to see the judge in that case making the distinction between the lawfully acquired and unlawfully acquired books, which makes some sense, I think. But in the case of Kadri versus Meta, which we discussed in episode 182, Meta won its case on the idea that the AI training is transformative, therefore fair use. But the judge cautioned in that case that Meta really won because the authors had not made the right arguments. I think either at pleading or in the summary judgment hearing. But anyway, the point being, Meta won. At least in their case, it looks like transformative use and therefore fair use. What's interesting really is the contrast between how the Bart's case and the Meta case, the Kadri case, handled things. The two courts handling this piracy question very differently, with Kadri sort of ignoring the question of piracy and just getting right to the point of the use itself. And piracy was a major issue in Bart's, where the judge did look at how the works were acquired. And so there we have it. There's our results. Those are just a few of the decisions that we've seen in the AI world, and there will be more coming in 2026, I'm sure. And who knows how long in the future. So
Forever.
Yeah, right. So we also had there was a lot of follow-on, I guess you would say, of the Jack Daniels case.
Yeah.
We hinted that we were going to give a little preview of your presentation. So fill us in.
So we actually discussed, I think, most of these cases most recently in episode 183. Mm-hmm. Quick background. Up until the Supreme Court decision in Jack Daniels in 2023, we had relied on the Rogers test, determining when a third-party trademark is a fair use when it's used in a creative work. So it was a two-pronged test, whether the use of a third-party trademark has artistic relevance to the underlying work, and if it does, was it deliberately misleading as to the source or the content of the work. But it also left an area out that I've always been concerned about is, well, what if it's being used as a source identifier? What if that third-party trademark, what if you should analyze first if it was an infringement versus if there's artistic relevance? And this is where the decision in Jack Daniels comes into play that we've talked about numerous times over the last few years. It's important this year because there was a final decision reached in early 2025 in the Ninth Circuit. But in the Jack Daniels case, we had the dog toy that was a parody on the Jack Daniels bottle. And at the district court, the judge said, that's not a parody fair use. That's a trademark infringement. At the Ninth Circuit, they focused on the First Amendment expressive and parody nature and found in favor of the VIP products who created this dog toy. And then the Supreme Court found that the district court had it right in the outset. When a third-party mark is used as a source identifier, we don't ever apply that Rogers two-prong test. The case was remanded and reached a decision in 2025 where the court actually said VIP products won under the Rogers test, that it was not being used as a source identifier and that it was a parody. But they lost in the end because Jack Daniels won on tarnishment. So we kind of fast forward to some other cases we talked about this year. And one is Yuga Labs, which is the non-fungible tokens. Do you remember the Board 8 Yacht Club non-fungible tokens, where the defendant in that case not only copied the exact images, they named them the same and barely changed the name of their entity, and argued that, this was an expressive work. But the First Amendment defense failed under Jack Daniels. The court determined the defendant's use of the Yuga's marks were source identifiers for competing non-fungible tokens rather than for protected criticism. So they never reached that Rogers analysis. We also had another one discussed in episode 183, which is horror via Netflix. I don't remember if you remember that one, but it was a real-life drag queen performer, Vicky Vox, sued Netflix, alleging an unauthorized use of an animated version of her image and likeness in a series called Q-Force. The only place her image was used was in a teaser, which was maybe 10 seconds, versus a trailer, which is a much longer work. The Ninth Circuit reviewed Jack Daniels and affirmed the district court's ruling, which was reached before Jack Daniels, given the fleeting use of her image and likeness solely to perform some other expressive function on the Netflix show. The Rogers test applied, and Vox did not succeed. Another one we haven't talked about this year, but also came out in August, was Homevestors of America versus Warner Brother Discovery. It's out of the district court in Delaware. I don't know. Do you guys have ugly houses in California? Homevestors is. I've lost you, Gordon. As far as your sound.
Sorry about that.
That's okay.
Everything is beautiful in California. Of course not.
Everything is beautiful in California. Okay, so Homevestors sells ugly houses. Yeah. They're actually a company based out of Texas. And they sued Discovery over their TV show entitled The Ugliest House in America. For trademark infringement. There was a lot of issues discussed by the court, but as to Rogers, both parties' summary judgment motions were denied because there was not enough evidence in the record to find a genuine factual dispute over whether Warner Brothers' use of the marks was source identifying. So the judge found neither of the parties' arguments for summary judgment were persuasive. So it's important to note that even though we have Jack Daniels properties and related to, was this a source identifying use of that third-party mark, Rogers has not gone away. Yeah. But please be very careful. A lot of the Rogers case law, especially out of the Ninth Circuit, pre-Jack Daniels, may not be good law anymore. Mm-hmm. So... yeah. So anyway, I think we will continue to see this applied, and maybe it'll be a lot of more cases over the next couple of years, and then it'll just slow down. Yeah. As we kind of figure out the boundaries of what's happening with the law. So we'll see.
Okay. Well, so tell us again, where and when is this presentation?
Yeah. So hang on. I want to get it right. It's
January 20-something, you said?
January 22nd, 1 p.m. Eastern, mylawcle.com. I also noticed that our friend and colleague, Zach Strabeck, the game lawyer, is presenting with this organization earlier in January.
Oh, that's cool.
So if you want to go check out what Zach's up to, I think he's the first week of January.
My Law. Cool.
mylawcle.com.
Okay, cool.
Annual CLEs for
it's that
very
time.
Good price.
Right on. Well, another one of the big cases this year with big consequences is that one we hinted at earlier, coming out of the Eastern District of Louisiana, Vedder versus Resnick Music Group. Centering on the 1962 hit Double Shot of My Baby's Love, written by Cyril Vedder and Don Smith. Like many songwriters of that era, they signed their rights away early on in 1963 for $1 to a publisher. What a deal. And that decades later, after Smith's death and a complex chain of renewals and transfers, Vedder exercised his statutory termination rights under Section 304 of the Copyright Act, effective in 2022. Now, historically, traditionally, the industry has assumed that copyright termination really only allows authors to reclaim U.S. rights, and publishers continue to retain the foreign rights under those grants. But the successor to the publisher, in this case, which is Resnick Music Group, they claimed that they still own 25% of the song outside the U.S. And the court rejected that argument, at least at the pleading stage, and found it plausible that renewal copyrights, including those acquired from a deceased co-author's heirs, constitute a new estate that may include global exploitation rights, not just domestic. So the court also addressed termination itself and held that it's plausible, contrary to prevailing precedent, that termination under Section 304 can recapture worldwide rights, especially where the original grant was expressly a global grant. So the judge, Shelley Dick, sided with the view that U.S. copyright law creates a single copyright and that foreign protections flow from international treaties like the Berne Convention, rather than separate independent foreign copyrights. And the ruling really challenges decades of industry practices involving cases like, the Superman case, Siegel versus Warner Brothers and others. So kind of a big deal if that stands. Where do we stand on appeals now? Do you know?
I'm unclear. I would be interested to know if anyone's been successful in reaching this argument with as they terminate, or if they filed other cases based on this ruling. I'll be interested to know if it stands. Are you checking to see on the appeals?
I'm not able to look at it right now, but
okay, all right.
Anyway, that we'll report back on that. I'm sure we'll hear more about it and be able to report if and when it's appealed.
Right.
So
that I feel like that was early in 2025.
Yeah, we should have heard something by now. So the information's out there. If somebody wants to let us know, that would be great. And then we have a case called Little versus Yano County. Yano County? Do you know how that? It's a Texas.
Well, it should be Yano, but we say Lano.
Lano, okay. And how you say bear with an X, right? In another county in Texas?
Bear.
Yeah. Anyway, so
Bayer County.
Bayer County, right. Okay. So like the aspirin?
Yes, yes.
And X and Y, it's easy to get them mixed up, right? So
that's right.
Anyway, Little versus Llano County.
Llano. The Spanish is Llano, right? You don't say those L's.
Right. Another Y, right? Anyway, So the question in this case was about government officials removing books from public libraries based on disagreement with those books' viewpoints, and whether or not that was a violation of the First Amendment. In this case specifically, it regarded LGBTQ and racial themes in the books. And the question is really whether that curation is a violation of free speech or whether it's itself is government speech. We talked about the case back in June, episode 181, and the Supreme Court has now declined to hear the case without stating any reason. December 8th just denied cert. So the case started when 7 Texans launched a challenge, this is back in 2022, to the removal of 17 books that included topics on race, gender, and sexuality. And they won a reinstatement of those titles at the district court. Then they took it up on appeal, and I thought I saw that there was initially a 3-judge panel that upheld the lower court, but then on banc, the appellate court, the Fifth Circuit, 10-7 ruled in favor of the books being removed, siding with the defendants, and said the right to information couldn't be invoked to push back against a public library's decision about which books to keep and which to remove. That act of curation, right? So among the dissenters, one of the judges, Stephen Higginson, called the arguments disturbingly flippant and legally unsound, but nonetheless 10-7 ruling. So the Supreme Court has now denied cert, leaving the Fifth Circuit Court of Appeals ruling saying First Amendment doesn't acknowledge a right to receive information. And similarly to that Disney case that we talked about at the top of the show, right? Mm-hmm. The act of curation is itself expressive speech. And here in this case, it's the government that's engaging in that act of curation. So it's government speech. And that's an interesting doctrine in First Amendment.
Right.
The government can make choices about what to include in its speech. So there we go. The county, what the plaintiffs have called a censorship campaign by the county government And there's other places where book bans are taking effect in throughout the South, but Texas in particular. So critics say that leaving this ruling in place was a missed opportunity for the Supreme Court to clarify the constitutional status of public libraries, and it leaves a big gap of certainty in where different parts of the country apply different standards. So we may see this issue again. So
I think we will see this issue again.
Yeah. So that's sort of it for our big roundup of cases for the year. The things we're looking forward to in 2026. Just last week, December 1st, well, 2 weeks ago now, December 1st, was the oral argument in the Cox case, Cox versus Sony Music. That's that giant $1 billion judgment for contributory infringement by file sharers, with the file sharers that Cox apparently didn't do anything to follow the data.
And it's been going on forever.
This has been going on for quite some time. So we expect that sometime probably by mid-2026, we will have a Supreme Court ruling on that. It'll be interesting to see what happens there. What else did we say? We're going to be looking at the outcome of Vedder versus Resnick. There was another one we mentioned a few minutes ago. That was
the year of another year of AI.
Right.
I mean, and what will that look like? Will it be settlements? Will it be a change in what the U.S. Copyright Office has to say? I don't know. I don't think it will be. I think the U.S. Copyright Office white paper from earlier in 2025. You know what? We didn't talk about that. I guess we did say that, but obviously there was the white papers that came out as far as the Copyright Office's stance on AI early this year, which led to some people losing their jobs. And
apparently now the Supreme Court has now ruled on that, I think, or a similar case regarding a termination of a congressional office.
Right, that they didn't have the authority. So
so we may see some more follow-up on those, fallout from those kinds of decisions and things like that. What else do you think will be happening in 2026 other than AI and that? Is the Congress going to do anything that's going to matter for our audience?
So I know we, at least on the music front, there's still been another introduction of like the Music Fairness Act. And so maybe we could have some movement on that as far as AM radio stations, or not AM, but terrestrial radio stations finally getting in line with the rest of the world and paying a public performance royalty to the artist and sound recording owners. That would be fantastic.
And in fact, just last week, the USPTO issued a letter to Congress on that subject, endorsing a public performance royalty for recordings.
So I would love to see some movement on that for next year. I think the other thing we're going to be seeing a lot on, and this again, it's AI. Do the states have the decision-making process to issue their own AI guidance?
Oh, yeah, because the
rules and regulations.
The White House issued an executive order on the subject.
The executive order that it needs to be federal. And so I think we'll see a lot of that.
That raises an interesting question. Can the White House, by an executive order, preempt a state law? I thought that was Congress's purview.
I don't think so. That is.
But
so, and maybe just an interesting political issues with Texas. We have a law.
Yeah. So does California. I think President Trump's reaction
so
was
we have a Republican governor, but we have a state law dealing with AI. So
okay, well,
there you go.
We'll see.
I think we'll see a lot on that as well.
Yes, indeed. And hopefully it'll be a wonderful year for everybody, and things will, the economy will point in the right direction for those of us who are sensitive to that and all of that. I'm looking forward to 2026. And in our next episode, we will, of course, talk about some of the big copyrights that have fallen into the public domain, as we always do in our January episode. As you know, January 1st is public domain. Actually, December 31st is January. Public domain day is January 1st. Everything.
Hey, I think it's that 12:01 a.m.
That's right. Everything.
And we'll do what I always love to do, and maybe we'll make a note in the show notes for everybody, which is to look back at our predictions.
Yes.
From last year and see if we got anything right.
I think we predicted AI was going to be prominent in our.
Yeah, I think we're good to predict that every year, but we'll see if we made any specific predictions that we got right or got terribly wrong.
Indeed. Well, as you can probably tell, we're coming to the end of our rundown for the show this week or this month, and we want to say thank you to our loyal listeners. We do appreciate. We're grateful to you for spending your time with us. And hey, listen, if you like the show, tell a friend, tell a bunch of friends, and let's spread the word. And of course, share the episode with them. And we invite any new listeners, please do, like, subscribe, and all of that. If you're watching us on YouTube, hit that notification bell so you know when the next episode's coming out and things like that. And if you have any feedback, we love feedback. So leave it for us. Use the voice widget on the website. It's entertainmentlawupdate.com. Over on the right-hand side of your screen is a little red tab, and you can click on that, and it'll turn on your computer mic, and you can record a little message, which we will play to our audience, assuming it's suitable for playing to the public. And then, or you can email us at entertainmentlawupdate@gmail.com. And Tamera, tell folks how to reach you.
Yeah. Well, happy Hanukkah and Merry Christmas. Absolutely. And Happy New Year's to you and your family. Mm-hmm. Folks can reach me at harperbates.com or createprotect.com. On most social media sites, I am at Tamera Bennett. And
I'm Gordon Firemark from Los Angeles. The website is firemark.com. My email address, gfiremark@firemark.com. Social media, you mostly find me as G Firemark. Instagram, it's Gordon Firemark, all one word. And let's say thanks to our crack team of volunteer contributors. We have John Janicek, our managing editor, who has been with us a really long time now. John, I have to ask you, how long have you been out of law school now? Because he joined up, I think, when he was at 2L, and now well entrenched in practice, and seems to be going great for him. Anyway, Charles Thorne is with us and has been for a while, and we appreciate his input. Alexis Allen contributes to these episodes, as does Violet Zhang and Dawson Holder. So if you are interested in joining the team and being a part of the little family of contributors that put these episodes together, reach out. entertainmentlawupdate@gmail.com is that email address. Send over a little quick cover note and a resume, and I'll be in touch with you about it. And with that, I'm going to push the button, and we'll go to our music and say that's a wrap, folks, for 2022. Thanks again for listening. Happy Hanukkah. Merry Christmas. We will see you next year. And until then, that's showbiz.